Mr. President, can you explain why you did not condemn those hate groups by name over the weekend?
They've been condemned. They have been condemned.
And why are we not having a press conference today? You said on Friday you'd have a press conference.
We had a press conference. We just had a press conference.
Can we ask you some more questions, sir?
It doesn't bother me at all, but I like real news, not fake news. Give fake news. Thank you, everybody. Thank you.
Hello, I'm Hat, and welcome to Hat's Gorilla Channel. Let's start with the basics. Why the name Gorilla Channel? In case you missed this story, here's a brief overview. Back in January, Michael Wolff's now discredited book on Trump's White House, The Fire and Fury, took the American left by storm. Taking advantage of a breathless reading public, Twitter user Pixelated Boat tweeted out that Trump had demanded a Gorilla Channel to be on his bedroom TV. The tweet was a blatant falsehood, but several confirmed Twitter pundits fell for it. One was a good sport about it, but most pretended they had never retweeted it in the first place. When I decided to start covering news from an alt-media perspective, piggybacking off of my All Hat No Cattle channel, Hat's Gorilla Channel felt perfect. Today I'm going to cover one question. Should federal district courts be allowed to block national policy decisions? I'll be looking specifically at the spate of rulings regarding Trump's immigration policies, namely the travel bans and DACA. Here's the background. In January of 2017, President Trump announced an executive order indefinitely barring Syrian refugees from entering the U.S. It included a temporary ban for 90 days against travelers from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, all countries with ties to state-sponsored terrorism. I'm linking to the entire order in the description. One should note, this list of countries was first put together by Barack Obama in 2016, who described them as countries of concern. This first travel ban was fatally flawed, specifically in its cancellation of temporary visas or green cards, thus preventing those who held them from re-entering the U.S. if they were out of the country when the ban took effect. There was turmoil at a number of U.S. international airports because of this, as many customs personnel were unaware of how to proceed in such circumstances. Also, protesters of the ban choked U.S. international terminals, resulting in even more chaos. 7 federal district courts, including ones in Hawaii and California, blocked the first travel ban, and the Trump administration backed away, issuing a new one due to take effect on March 16 of that year. They dropped the green card provision and the ban on travelers from Iraq. Federal courts in Washington State, Maryland, and Hawaii, again, moved quickly to block this executive order as well. The administration filed an appeal and lost in 2 separate rulings. A second federal appeals court has ruled against President Trump's revised travel ban, delivering on Monday the latest in a string of defeats for the administration's efforts to limit travel from several predominantly Muslim countries. The administration has already sought a Supreme Court review of a similar decision issued last month by the United States Court of Appeals for the Fourth Circuit in Richmond, Virginia. Monday's decision came from the United States Court of Appeals for the Ninth Circuit in San Francisco. The 2 courts employed different reasoning to arrive at the same basic conclusion. The Fourth Circuit said the revised executive order violated the First Amendment's prohibition of government establishment of religion. The Ninth Circuit, by contrast, rested its conclusions on statutory grounds. It said Mr. Trump had exceeded the authority Congress granted him in making national security judgments in the realm of immigration without adequate justification. It was then obvious that the fix was in, as these courts' arguments were well outside of their jurisdiction. Remember, these are district courts. Their rulings are to only cover cases within their area of responsibility, not national policy. Citing such bull as saying the travel ban was a ban on Muslims, thus violating the First Amendment's ban against a state-sponsored religion, totally ignores the facts that the ban affected countries, not individuals. These countries are not 100% Muslim, and non-citizens are not protected by the Constitution. Add to that, the Constitution grants the president the exact powers Trump was exercising in these orders. The appeals courts were way out of their league. Trump, needless to say, was flabbergasted by these losses, calling the rulings, quote, an unprecedented judicial overreach, unquote, and suggested they were political acts, adding that they made America look weak. In what turned out to be a misplaced trust of the appeals courts, the Trump administration fought to have these decisions overturned. That was not going to happen. Perhaps anticipating these rulings, the administration had already filed for the second travel ban to be reviewed by the Supreme Court. SCOTUS handed down its findings on June 26, and it was a victory for Trump, though not a 100% vindication. In short, SCOTUS ruled the ban valid, striking down the appeals court's arguments, though exempting people who have what the court called any bona fide relationship with a person or entity in the United States. It also said it would make a full decision during its next session. Preceding the High Court's ruling, in September of 2017, Trump announced the third and current iteration of his travel ban. This bars or limits entry by people from Iran, Syria, Chad, Somalia, Libya, and Yemen. The ban also blocks people from North Korea and a handful of Venezuelan government officials. What was the federal district court's response? Challenge it, of course. State Attorney General Doug Chin said the new ban still discriminates on the basis of nationality, exceeds the president's legal authority, and seeks to implement his Muslim ban. This is beyond the pale. Chin is a state's attorney. He has no business meddling in the affairs of the federal government. Chin has been challenging President Donald Trump on travel bans since February, after Trump sought to bar new visas for people from 7 mostly Muslim countries. At least they called it a travel ban and not a Muslim ban. Once again, Trump had the Supreme Court mostly behind him. Earlier today, the Supreme Court issued 2 orders stopping implementation of lower court injunctions that had temporarily blocked implementation of President Donald Trump's third travel ban order, which permanently bans entry into the United States by most citizens of 6 Muslim-majority nations, as well as imposing mostly insignificant restrictions on citizens of North Korea and Venezuela. These orders do not resolve the legal challenges to Trump's latest travel ban, but they do allow it to go into effect at least until the lower courts reach final decisions on its legality. With what had to be full knowledge the lower courts would once again put politics ahead of the Constitution, the White House had no choice but to yet again appeal to the Supreme Court in January of this year. We've now arrived at the DACA portion of this video. Here's a brief overview of what it is. Deferred Action for Childhood Arrivals, or DACA, is a kind of administrative relief from deportation. The purpose of DACA is to protect eligible immigrant youth who came to the United States when they were children from deportation. DACA gives young undocumented immigrants protection from deportation and a work permit. The program expires after 2 years, subject to renewal. I've included a link to the wiki article on DACA as well, but here's a very brief history. It all started with the so-called DREAM Act, a bipartisan bill that would have allowed citizenship for illegal immigrants who came to the U.S. as accompanied minors. Those covered under the act became known as Dreamers. The bill was first proposed in 2001 and again in 2011, but never passed the Senate. President Obama created the DACA program via executive order in June of 2012, with applications accepted that August. Over 740,000 initial applications were approved. In November of 2015, Obama proposed to expand DACA coverage significantly, but it was challenged by a Texas state court, winding up in front of the Supreme Court. SCOTUS split on the issue 4-4, leaving the injunction in place. DACA has a dirty little secret. It never passed Congress. Both houses must approve changes in the citizenship status of non-U.S. residents. The president must then sign the bill into law. By creating DACA through an executive order, Obama bypassed that process, thereby making it unlawful. In June 2013, all House Republicans plus 3 Democrats voted to defund DACA, led by Representative Steve King of Iowa. Quoting Representative King, "The point here is, the president does not have the authority to waive immigration law, nor does he have the authority to create it out of thin air, and he's done both with these memos in this respect." Fast forward to June 2017, when Trump's Department of Homeland Security announced the repeal of this program. 3 months later, Attorney General Jeff Sessions repeated this. March 5, 2018, was pronounced as the deadline for DACA becoming law, or it would be ended, making the deportation of Dreamers possible, something Donald Trump had promised during the presidential campaign. Enter the New York Federal District Court and, of course, the Ninth Circus. That brings us to now, and back to my question. Should federal district courts be allowed to dictate national policy? In a word, no. They have no standing when it comes to matters not involving particular cases for particular individuals, especially ones that fall outside of their districts. What do I mean by that? Let's take, for example, the case of Jack Phillips, the Christian baker in Colorado who didn't want to decorate a cake for a same-sex couple's wedding. Phillips felt it was against his religious tenets to support homosexuality. He offered to sell the couple something else, but said he would not create a custom cake. In retaliation, the couple did their level best to drive the baker out of business, costing him extensive material harm. As an aside, Colorado had not yet legalized same-sex marriage. Not satisfied with taking Phillips' store, Masterpiece Cake Shop, to the cleaners, if I may mix metaphors, the gay couple, David Mullins and Charlie Craig, filed a complaint with the state's Civil Rights Division, claiming Phillips violated state law. Phillips was found guilty, a decision he's fought all the way to the Supreme Court, arguing he has a First Amendment right to freedom of religion and should not be forced to do something against his beliefs. Here, the lower courts were dealing with a specific situation involving specific individuals. That's their job, not overreaching and making political statements on broad issues such as immigration policy, First Amendment rights of people who aren't even citizens, thereby not afforded those rights, and pushing for the renewal of an illegal executive order. Those are matters of policy and not in their purview. Here is what I consider the definitive take on this subject. This is an article in the Conservative Review posted May 1st of last year by Daniel Horowitz. Constitutional fact: district judges can't strike Trump's orders. A district judge has as much power to strike down a national policy or statute and have it take effect outside his district as much as Congress has the power to adjudicate an individual bankruptcy case. That is to say, they have no such power at all. Judicial review, at best, grants judges a co-equal authority in interpreting the Constitution just for the purpose of an individual case with legitimate standing before the court as part of its dictate to exercise only the judicial power. However, the notion that courts would serve as the superior or exclusive word over all matters of national policy and apply individual cases as national law without opposition from the other branches is ludicrous. As absurd as it was for the courts to bastardize the Immigration and Nationality Act, executive power, the Constitution, federalism, and sovereignty, the fact that they applied their decisions outside of their individual case or controversy, by definition, violates the separation of powers. Professor Samuel Bray perfectly explains this problem as follows. The U.S. Constitution gives the Supreme Court and the lower courts the judicial power. Courts decide particular cases for particular parties. They do not decide abstract questions for all possible parties. Related to this is the principle that the federal courts have authority to give traditional, equitable remedies. But the national injunction has no basis in the tradition of equity. For the first century and a half of the federal courts, there were no national injunctions. I can't put it any better than that. The raw political underpinnings of these federal injunctions, which have been struck down time and time again by the Supreme Court, are proof positive that Trump derangement syndrome is not limited to the mainstream media, pussy hat wearers, or members of Congress. Federal judges are lifetime appointees. They can't be replaced by simple presidential fiat. That's what gives them such overarching power, power that has gone straight to their tiny little heads. I'll end things here. I'm quite surprised at the scope of this channel's first video. I was initially going to do a few articles, but this idea hit me last night and I felt I had to make this my premier effort. I look forward to your comments on this piece. I have a feeling a great discussion is brewing. Please tell your friends about Hat's Guerrilla channel and share this video wherever you can. Don't forget to check out the links in the description. I've included all of the articles referenced here, as well as shortcuts from my primary channel, All Hat No Cattle, my social media accounts, and my maker support page. Until next time, be well, and as always, thank you for your attention. Oh, that was a good one!